Okay, it is 2 o'clock, so we are going to come back and begin our next session. For those of you who don't know me, I'm Kathy Mahoney. I am one of the attorneys at Abner Weicker, and I'm based in Pennsylvania. I handle cases all over Pennsylvania. Um, Primarily, I handle cases involving student discipline at the K through 12 and higher ed levels. That includes code of conduct cases, academic violations, Title IX cases. I also handle educator misconduct cases, separation agreements, things like that. And today I'm going to be presenting to you on the First Amendment. Before I do that, a quick little fun fact about me. As I said, I'm based in Pennsylvania. I live in Pennsylvania, but I also split my time between Pennsylvania and the Delaware beaches. So if I'm not in Pennsylvania, you will likely find me on the beach somewhere in Delaware. But for today, I'm here in Pennsylvania, and I'm very happy to be speaking to you about this very important topic. Um, when we were coming up with topics for the conference this year, one of the topics that was kind of thrown around was the topic of the First Amendment. And this was particularly interesting to me because in the past year, I have actually had the opportunity to represent two different students at the higher education level on specific First Amendment issues. And without, of course, revealing my confidences, I'm going to give you just a little bit of background about each of these cases to start off with so that you can think about it as I go through my presentation. Then at the end, I'm going to come back and ask you how you think those cases should have turned out. So case number one, I represented a student at a public university who had used a racial slur on their social media and faced expulsion from their fraternity or sorority at the public university as a result of using that racial slur. So that's student number one. Student number two that I represented, again, posted higher education, posted on social media a post that was pro-Hamas, anti-Israel. That student is a student at a private university, and as a result of that post, faced backlash from one faculty member who proposed the student should be dismissed from their academic program because of that incendiary post. So student one and student two, think about how you feel about those posts, whether those posts in your mind should result in the university taking action against them or not. And we're going to talk today about the law as it pertains to these types of situations. We're also going to focus on freedom of speech rights for students K through 12 as well. So my presentation is broken sort of in half. The first half will be devoted to freedom of speech rights K through 12. The second half will talk about university higher education rights. All right, so for those of you who may not know, who may not be an attorney that are attending today, I thought we should just start off with a really quick overview of the First Amendment, because I find that people tend to be maybe not fully aware of everything that's included in the amendment. So here it is. Here's the actual verbiage of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble or to petition the government for a redress of grievances. So that is the actual language as it's stated in the First Amendment. And I'll just quickly mention that the three states that we're focusing on in our conference today, so Pennsylvania, Ohio, and Michigan, all three of those states have a similar freedom of speech provision written into their state constitutions as well. And I didn't link those here, but you can easily find them on Google if you're curious to read about them. But let's take this language of the First Amendment and just like break it down to its elemental parts. Basically, the First Amendment guarantees 5 rights: the freedom of press, speech, peaceful assembly, religion, and the right to petition your government for a redress of your grievances. So 5 different rights are guaranteed just within that one sentence. It's pretty fascinating. Today, we're going to focus on 2 of these. We're going to focus on speech and, to a lesser extent with higher education, peaceful assembly. So the other 3 we're going to have to leave for another day. And I can tell you, we could talk for hours. You could take an entire semester of a course on each one of these 5. So again, today we're going to just be talking about speech and peaceful assembly. Just another quick little tidbit, a little factoid, if you will, about the First Amendment. It was first ratified in 1791 as part of what we call the Bill of Rights. That's the first 10 amendments to the Constitution. Those first 10 amendments came real quickly, right after the Founding Fathers and the colonies, the then colonies, ratified the Constitution. They quickly realized that they needed to add a recitation of the specific rights that American citizens had, and those are contained within the first 10 amendments. Now, here's the interesting thing, particularly about the First Amendment. So it's ratified in 1791, but we don't have any cases that actually interpret it until 1919. So we've had the amendment for 234 years, but we really only have a little more than 100 years of interpretation and development. And as you're going to see, the bulk of the development of the civil came during the civil rights era, the 1960s. That's when we start to see the Supreme Court really looking at the First Amendment and determining the parameters of it in all different aspects of life, not just education. But you should know that many scholars of the civil rights movement attributed to the First Amendment. It's that ability to speak out against your government, to be openly, verbally critical of your government, to engage in marching against your government. These are the things that took hold and led to the wide sweeping changes that we saw during the 1960s and then later during the 1970s. Okay, so that's the backdrop against which we're going to focus on how free speech works in the context of education in America. So one last piece, this is a general overview of the First Amendment. Let's talk about what is not protected free speech. Now I have I have several bullet points up for you. I will briefly explain these. This is a high level overview. It is by no means an in-depth deep dive into each one of these. Again, you could take a semester-long course on each one of these. So I'm just going to briefly describe, and this is particularly for those of you who may not be attorneys, may not have taken a constitutional law class or sat through the bar exam. You may not be aware of these. So these classifications of speech are not protected under the First Amendment. So the first is obscenity. So what is obscenity? Well, our Supreme Court justices have said, well, I don't really know what the definition of obscenity is, but I know when I see it. I know it when I see it. But they have developed a definition, essentially any type of speech or expressive language that appeals to the sexual interest, that is objectively, patently displays sexual images in an offensive way and lacks any sort of artistic or literary or scientific purpose. That would count as obscenity. And again, that's a very general, high view definition. But things that are obscene are not protected under the First Amendment. Next, we have defamation. Again, a very high level definition. Defamation is when one person or entity speaks falsely and negatively about another entity. So in order for there to be defamation, there has to be a statement that is false and injurious to someone or something's character, that is published, in other words, spoken or made known to a third party. Those in general are the elements of defamation. Defamation can take the form of oral defamation, which is what we call slander, or written defamation, which we call libel. So defamation is not protected under the First Amendment. There are more rules that apply if the person who's being defamed is a public figure or not. That's beyond the scope of today's presentation. But if you'd like to talk to me more about defamation, I'd be happy to do that. So just hit me up after the presentation. Okay, incitement to imminent lawless action is not protected under the First Amendment. What does that mean? If your language is specifically inciting others to violence immediately, right now, that is not protected. So I will tell you folks that I have taught a course, a constitutional law course, maybe about 20 times now. And ever since the January 6th insurrection at the Capitol, we have studied Donald Trump's speech that preceded that insurrection with the intention of digging apart his words to determine whether they rise to the level of an incitement to immediate lawless action. Without getting political today, I will tell you that there are arguments to be made on both sides of that, and certain people argue strenuously that he did not incite imminent lawless action. Others wholeheartedly disagree, and you can watch his speech for yourself and see what you think about his words that day. True threats are also something that are not protected. Now, again, what is a true threat? A true threat means that you are threatening to hurt someone concrete immediately in the future. It has to be a serious expression of an intention to commit a violence against a particular person or group. Anything that's just sort of nebulous or general in nature will not rise to the level of a true threat. A true threat has to be, I am going to hurt you or your group immediately. Okay, so general, bellicose words on social media that are generalized and not directed to a specific person probably don't rise to that level. Same thing with fighting words. Fighting words are not protected by the First Amendment, but it is defined and interpreted by the court very narrowly. It's a face-to-face confrontation. It's only when one person is saying something that is likely to encompass an immediate violent reaction from the recipient of the words. Speech integral to criminal conduct. So you do not have a First Amendment right to use your words to commit a crime. So if you are a bank robber and you go into a bank with your mask and your gun and you say, give me all the cash in your cash register, that sentence is not protected by the First Amendment. And finally, fraud and perjury. So fraud and perjury are not protected by the First Amendment. Fraud would be if you are going to put an ad on Craigslist to sell your car, and there's really no car to be sold, and you take the person's money and you don't produce the car. That is a crime, and your words that you put on Craigslist are not protected by the First Amendment. You cannot defend yourself in court by saying, my words are protected as free speech. They are not. And finally, perjury, which is lying under oath, is also not protected by the First Amendment. Okay, so that's the backdrop. That's the general overview of the First Amendment. So now let's turn our attention to how does this play out in the context of education. So we're going to talk about K through 12 first. So the first major Supreme Court decision that we had where the court recognized that K through 12 age students do have certain rights to free speech. That first came in the case of West Virginia versus Board of Education. I'm sorry, the West Virginia State Board of Education versus Barnett. So this is a 1943 case. And in this case, Jehovah's Witness students brought a lawsuit challenging a West Virginia state law that required them to recite the Pledge of Allegiance and to salute the flag. The Jehovah's Witnesses students argued that that violated their First Amendment rights. It was not compatible with their religious beliefs that barred worship of idols. And they also said it constituted a violation of their free speech. The Supreme Court heard the case, a 6-3 decision, and the court primarily analyzed the case under the right to free speech and treating the flag salute as a form of symbolic expressive speech. The court held the government cannot compel citizens to express a belief that they don't believe in without violating the First Amendment. So that's the first time that we see the court putting limitations on the state's ability to restrict or to enforce speech, really in this case, of students. Okay, now we're going to jump ahead to the 1960s, almost 20 years later, where we have our next two big cases, Engel versus Vitale and Abington School District v. Schempp. For you fellow Pennsylvanians, Abington's right from our backyard, right outside of Philadelphia. Bradley Pitt graduated from Abington High School, little fun fact. But in both of these cases, the High Court, the Supreme Court, overturned state laws that mandated prayer or Bible readings in schools as violations of free speech. So we kind of see this evolution with free speech that comes to really a head in 1969. So 1969 is the height of the Vietnam War. It is the height of the hippie movement. These are tumultuous times in America. And what happens here is we have our first real case that starts to set boundaries on free speech in public schools. So the case is Tinker versus Des Moines Independent Community School District. And what happened in Tinker? Tinker was a family of a mom and dad, and I believe 4 students. And the Tinker family wanted to wear black armbands to school to stand in solidarity with then Senator Robert Kennedy, who was protesting the Vietnam War. So you can see in the picture, there's 2 of the Tinkers pictured there, as well as their armbands that they wanted to wear. So again, you have to remember the times that we're living in. This was extremely incendiary at this time. The Vietnam War was tearing our nation apart. So the Des Moines Independent Community School District got nervous, and they wrote a policy that said, any student wearing a protest armband to school will be asked to remove it, or they'll face suspension if they're unwilling to do so. The Tinkers wore their armbands. They were suspended. Their parents filed suit. The case worked its way all up to the United States Supreme Court. Now, the issue is, did the school's policy violate the students' rights? The court said, yes, it did. So the school district can limit students' free speech, but only under what the Supreme Court coined the substantial disruption test. The substantial disruption test, which says school administrators can limit free speech. They can. But before they do, they have to demonstrate that the speech that they want to restrict would materially and substantially interfere with the requirements of appropriate discipline and operation of the school. And in the Tinker case, they said these armbands caused no substantial disruption, therefore it violated the students' First Amendment rights. So Tinker's our big case. It still is the law as of today, which we're going to see in a minute. And subsequent cases have further refined and explained what we mean by the substantial disruption test. But basically, a school at the K through 12 level can restrict speech if it is reasonably forecasted that the speech will interfere with the school's work or with student discipline or with the rights of others. But the school cannot restrict speech if it is simply uncomfortable unpleasant, or unpopular. So there has to be some connection between the speech that's being regulated and the impact that it has on the school community in order to pass constitutional muster under Tinker. Keep that in mind as we go through newer cases. Let's see how Tinker has played out in the decades since it was first enacted. All right, the next case we have that I'm going to talk about is one from 1985. It's called Bethel School District v. Frazier. So I hope that you'll forgive a little bit of lewd language that I'm going to share with you right now, but in the spirit of my presentation, I think it's appropriate. So in Bethel, we have Matthew Frazier. He gives a speech nominating his friend Jeff for vice president of the student body. He gives his speech at a school assembly. Before he gives his speech, it is read by two teachers who tell him that it is not appropriate and he should not give the speech. He thought he was very clever. He was very tickled with himself, and he gave the speech nonetheless. Now I'm going to read to you some of the salient parts of the speech. Again, this is Matthew nominating his friend Jeff for vice president. He says, Jeff is the man who takes his point and pounds it in. If necessary, he'll take an issue and nail it to the wall. I know a man who's firm. He's firm in his pants. He's firm in his shirt. He's firm in his character. Jeff is a man who will go to the very end, even the climax, for each and every one of you. Okay, so that's the speech. This caused the students to react with hooting, hollering, making vulgar hand gestures. In addition, a teacher lost class time having to discuss this speech with the students. So as a result, Matthew is suspended for 3 days, and even more importantly, he is removed from the list of speakers who were meant to speak at graduation. So he lost his right to speak at graduation. As a result, his parents sued. This goes all the way up to the Supreme Court, and the Supreme Court holds that his punishment was okay. The school's conduct policy prohibited any type of behavior that substantially interfered with the student's education, including in that the use of obscenity, whether in language or gesture. So the court sided with the school district, said this policy of the school was legitimate. So I want to just point out a couple of things to you. Number one, this happened in 1985. So we're talking about 15 years after Tinker. We have a much more conservative Supreme Court in 1985 than we did in 1969. So keep that in mind. But in addition to that, there were some other factors that the court took into account. First of all, Jeff was warned ahead of time by two teachers not to give this speech. He was aware that the school had this policy against obscenity, and he ignored it. He was aware that there would be a consequence for delivering the speech, and he ignored that as well. So the court went on to hold that we do grant adults the ability to use offensive language, but we do not have to give K through 12 students the same latitude. So within the framework of this case, the court says, yes, school districts, you may have policies that prevent the use of lewd and profane language. So that was a victory for schools. And let's move on next. I'm going to go through just a couple of quick cases in the 2000s. Again, we still use Tinker. Tinker is our case, but let's see how it plays out. So in the year 2000, we've got the case Boroff v. Van Wert, City Board of Education. This is from the Sixth Circuit. So this is you Ohio folks, and I think Michigan too. A student wore a Marilyn Manson t-shirt to school, and that was deemed to be a violation of the school policy. The case went up to the Sixth Circuit, and the Sixth Circuit upheld the student's suspension, finding that this T-shirt promoted drug use, and therefore, under Tinker, under the substantial disruption test, it could substantially disrupt the educational process. Do you guys agree with that or not? I'm curious. Okay, now, next case, 2007, this goes up to the US Supreme Court. Students lifted a banner that read "Bong hits for Jesus" during a school activity. The Supreme Court struck that down. That is not protected free speech. And then next in 2008, interesting case. This is again out of the Sixth Circuit. So a student wore a T-shirt displaying a Confederate flag. So think about it. How is a T-shirt with a Confederate flag any different than wearing a black armband to protest the Vietnam War? They're both symbolic speech, right? Well, the Sixth Circuit disagreed. The Sixth Circuit upheld the dress code banning this clothing. So while it might seem like this case is at our odds with Tinker, the court actually fleshed out a number of key factors that led to its decision. So first of all, in the context of this school, there were already existing racial tensions. There was violence at this school, and there was an increase in absences among African-American students out of fear for their safety. So therefore, this school in this context could reasonably forecast that displaying this clothing could cause a substantial and material disruption, and therefore was permitted to ban the clothing from school. So while on its face it may seem to be similar, the court found that it wasn't. Okay, I see that our poll quiz is up, and we're going to talk about social media in a quick second. But do you believe that K through 12 schools should be able to regulate students' social media outside of school?
Kathy,
Yes.
you were asking our opinion about the Boroff case and Van Wert.
Yes.
And I just wanted to share that, like coincidentally, about 2 weeks ago, we took our summer interns to the Ohio Supreme Court for a tour. And they have an education center, and in the education center in the basement, they have that shirt like displayed, the Marilyn Manson t-shirt.
Oh, and what do you think? Is it a substantial disruption?
I don't think so. I think it was an overreach by the court.
Interesting. Okay, well, let's keep going because there's more cases. So let's talk about today, what's going on in 2025. So I have two pictures up on the screen for you. This is Liam Morrison. He is a 6th grade student out of Massachusetts, and he wore this t-shirt to school. There are only 2 genders. He was told to leave and come back and not come back until he changed his shirt. So he came back to school with the shirt changed. As you see in the picture on the right, there are censored genders. All right. You see his mom and dad are behind him. They filed suit. What do you think happened here? This would be a good poll question. But do you think the Supreme Court ruled in favor of his shirt or against his shirt? So I'll give you a minute to think about it. And now I'm going to tell you. The case did not make it to the Supreme Court. They denied cert. Okay? But the trial level court upheld the school's authority to ban the shirt. The case went up to the First Circuit Court of Appeals. They agreed with the trial court. School district, yes, you can ban this shirt. Goes up to the US Supreme Court. And by the way, right now, we have quite the conservative majority. So it's very interesting that they denied cert on this case. They allowed the decision of the First Circuit Court of Appeals to stand. They allowed the decision to stand that the school could ban this shirt. But I will note 2 very interesting dissents from Justice Thomas and Justice Alito, both conservatives. They held that this analysis was contrary to Tinker. They held, look, This shirt will not substantially disrupt the school, and therefore, following Tinker, this shirt should be allowed. The school should not be allowed to ban it. And interesting anecdote, Justice Thomas held, I don't think Tinker should be the law. I don't think we should have the Tinker standard. But as long as we do have it, we have to follow it. And under Tinker, this is the wrong analysis. So that was his dissent. But folks, what does that tell you about the current state of the law as regards K through 12 students? It seems like we are leaning more and more in favor of schools being able to regulate speech. Okay, so let's talk about social media and internet speech, because you guys, this is the huge area that's happening, both K through 12 and university level. Okay, so whether schools can punish the students off campus speech will depend on the circumstances. So in general, students have the right to speak outside of school, use social media, even if their speech is vulgar, crude, or offensive. More recently, courts have considered additional factors. So 2021, we have a student who posts on her social media, F school, F cheer. She gets in trouble. It makes its way up to the US Supreme Court. By the way, this is Mahanoy Area School District, another Pennsylvania case. And the court said in this case, you know, this is not appropriate for the school to regulate. Number one, it occurred outside of the school building. Number two, outside of regular school hours. Not three, not during the school-sponsored activities. Number four, it was only directed to a private group of her friends. It wasn't posted in general. It did not target, it did not threaten anyone. It didn't target any specific person with abusive or vulgar language. Therefore, the school overstepped by punishing her for minimally disruptive speech. So there you go. That's 2021 case. But here are the times when the school may be justified in responding to off-campus speech. So if we have serious or severe bullying or harassment targeting an individual, if we have threats aimed at particular teachers or students, if there's a failure to follow rules concerning like lessons, writing papers, anything like that, or if there's a breach of the use of school security devices. In those instances, then yes, the school may step in. Here's another Pennsylvania case, AF v. Ambridge Area School District. The court held that the students' off-campus Snapchat messages were not protected and could be punished by the school because they were not merely profane, but they were actual threats targeting another student. So that's really where we draw the line. If you are actually threatening another student, another teacher, if you're misusing the school equipment, or even just bullying, not threatening, but just bullying as well. Those types of speech can be punished by the school, even if they happen outside of school. And then in 2022, we have another case out of the 10th Circuit where the court ruled in favor of the student. This student posted something racially offensive, but it was not a substantial disruption at school. It wasn't directed at any particular student, so therefore it was protected. Okay, so I just have up here a brief summary of rights, and in the interest of time, I'm not going to spend too much time on this, but you can read this on your own. These slides will be available for you. But these are the things the students are allowed to do and they're not allowed to do. They can opt out for standing for the Pledge of Allegiance. They can distribute materials. They can wear clothes and symbols that represent their gender and cultural identities, participate in walkouts and silent protests, express themselves freely on social media, as long as they don't substantially disrupt the learning environment. What is a substantial disruption of the learning environment? What counts? Well, interrupting class, so instructional activities are interfered with, threats of violence, racially harassing conduct, fighting or violent behavior on school grounds, and the schools must have evidence that a disruption will occur in order to limit speech. Now, there's a section here about school-sponsored speech. And in the interest of time, I'm going to temporarily pass over that, and I'll come back to it if we have time, because I want to make sure we have enough time to talk about higher education. All right, so we're going to shift gears now. We're done talking about K through 12. Let's talk about college and graduate and professional level schools, so higher ed. So the students at the higher ed level have significant First Amendment rights, but they are not absolute, and they are subject to reasonable restrictions. Here's where it gets a little complicated. Different standards apply to public and private universities. So we're going to start with public universities first. So public universities are bound by the First Amendment. Okay, they are government, they are a government entity, they're an arm of the government, and therefore they are strictly bound by the First Amendment. They cannot restrict speech based on content or viewpoint. Permissible restrictions on free speech exist if they are neutral and they regulate time, place, and manner of the speech to prevent, again, a substantial disruption to the school's essential functions. In other words, the school can direct when you can have your protest and where, so that it doesn't disrupt the operations of the school. But the content of your protest cannot be the basis for denying you the right to protest. So let's go through a couple of examples of protected speech at the higher ed level: wearing expressive clothing, distributing flyers, collecting signatures for petitions, campaigning for change, and participating in peaceful protests. These are all protected by the First Amendment. Public universities, what counts as a substantial disruption? Well, if you are disrupting classes, if you're having your protest right outside of the chemistry lab during the chemistry final exam, that is not appropriate. The school can restrict you from doing that. If you're blocking entryways, if you're giving speeches that call for immediate lawless action, if you are truly threatening violence, these are not protected. So again, let's just really quick run down, where is that line? Where do we draw that line between what's protected and what's not? You may not give a speech that directly incites imminent lawful action. You cannot have a true threat of violence. And I apologize, Mark, I am missing a quote there. You cannot give a speech that is defamatory, that contains obscenity, or that is harassing to another person in a way that is severe, pervasive, and objectively offensive. Okay, those are not free speech. Now, private universities are different. Private colleges and universities generally are not bound by the First Amendment. They are not government entities. They are not an arm of the government. However, most private universities voluntarily commit to upholding the First Amendment. Frequently, they will have a policy in their student handbook that says that they will adhere to the tenets of the First Amendment. When that happens, they create a contractual duty for themselves to honor the First Amendment for their students. And then some states, like California, have their own state statutes that extend First Amendment protections to the private colleges and universities. The three states that we are primarily focusing on today, Ohio does have a similar statute, and I've put it there for you so you can refer to that if you'd like to read it. Michigan and Pennsylvania do not have specific laws guaranteeing First Amendment rights for their private colleges and universities. All right, current issues, hate speech. So where do we draw the line for hate speech? So while hateful or offensive speech can be addressed through educational initiatives, a university statement is generally not sufficient grounds for censorship under the First Amendment unless it rises to that level of harassment or a true threat. Non-citizen students have to be particularly careful, because if they are arrested, even without criminal charges, they could negatively affect their visa or their ability to enter or remain in the US. This is really serious. Even if you've done nothing wrong, just being arrested in the United States is sufficient to jeopardize your visa, your status for being here. So you must keep that in mind if you are deciding to participate.
Kathy,
And
this is your 10-minute warning.
okay, that's my 10-minute warning. Now, I wanted to use an example, Columbia University and things that have been going on there. I do have a summary of what's going on, as well as a summary of students' free speech rights at higher education. So you can read those on your own. But let me ask you the two questions that I asked at the beginning of my speech. So student one was dismissed from a fraternity or sorority at a public university for using the N-word on social media. Student two goes to a private university and is facing backlash and potential discipline for posting an anti-Hamas post on their social media. So what do we think? Proper school action or a violation of the First Amendment? Any thoughts? Well, you can think about that, and I'll just ask if we have any other questions in the Q&A.
Yeah, I was gonna say people can answer in the Q&A what their thoughts are. I know I have some thoughts, but actually, Kathy, one of the questions that we had for you was, can you discuss the protests that were happening about Palestine and how students were getting arrested at universities? And how can schools get away with arresting those protesters and subjecting them to discipline? So I think actually talking about those Columbia cases would be great.
Okay, so I want to tell you there are pro-Palestinian, anti-Israel protests happening on lots of college campuses. I chose Columbia as kind of an example because Columbia has kind of distilled as the epicenter of where this is happening. And I'll just try to give you the really high overview. It started in 2024. Pro-Palestinian protests started at Columbia. There were tent encampments in the common areas of the school. There were building occupations, which it became a central point of contention. There were clashes between university administration and students. So the problem is some students and faculty argued that the university's response to the protests suppressed free speech, that what they were saying was protected free speech. It wasn't harassment. It wasn't true threats. It wasn't obscenity. It wasn't in any of those categories. That's not protected. All right. But others, including the Trump administration, strongly criticized the university for tolerating anti-Semitism on campus. They formed a university task force on anti-Semitism, which highlighted instances of the Jewish students on campus feeling marginalized, facing hostility, being very concerned for their safety, and just there was a lack of inclusivity on campus. So we have this, this Middle Eastern fight has visited us on American shores, and we have both sides fighting. The Trump administration strongly disfavors the protesters, has threatened to cut federal funding to Columbia due to its perceived inaction on anti-Semitism. This led Columbia, it seems like Columbia has more or less capitulated, and you may disagree, and certainly there are so many different opinions about this, but Columbia has agreed to make policy changes, and many people think that Columbia should not capitulate to the Trump administration. Others think that Columbia has not gone nearly far enough in addressing anti-Semitism. It's just all over the place. It's led to others expressing concern about overreach from the executive branch, violations of academic freedom and university autonomy. But since we're focusing on First Amendment issues, I will tell you that as of March and April of 2025, the Trump administration froze all funding as a punishment, basically, for not addressing the anti-Semitism. They placed a list of demands on Columbia, which included disciplining the students who were involved in the protests and reviewing academic departments that include Middle Eastern studies. There's a spate of other litigation pending as well, Title VI, Title IX, those types of things. And what I don't have on the slide is one of the main protesters, Mahmoud Khalil, was arrested by ICE. He was a graduate student at Columbia. He was here legally. He was arrested by ICE. He was held in Louisiana at an ICE detention center for over 100 days. He is facing deportation. And he's been allowed out on bond. And I checked this morning just to see what his status was. So he's out on bond. And he has recently filed a $20 million lawsuit against the Trump administration for a violation of his First Amendment rights. So all I can say, folks, is this is just blowing up across the country. Columbia appears to be the epicenter. Harvard is not capitulating. We just don't have time to talk too much about Harvard, but they are fighting the Trump administration. And so you just really need to watch this space as it unfolds in real time. Okay, other questions?
There is one other question regarding social media posts. Would a student that is also an influencer face increased scrutiny when evaluating free speech?
You know what? I feel like that's a great question. And my answer would be, I think that the more visible you are on social media in general, the more scrutinized you're going to be. And that I would imagine, include a school as well, if you are influencing the culture of your school, if negatively or positively. So, again, we come back to the substantial disruption test. If your online speech is creating a substantial disruption in your school district, then and I'm assuming you mean K through 12, but it really doesn't matter either way. If your speech is causing a substantial disruption in your school community, then it can be regulated by the school. And, I think what I took away from the cases, the more recent cases, it really depends on the circumstances in which the speech exists. We don't just look at the speech in a vacuum. We look at the impact it has on its community in just determining whether it has had a substantial impact or has substantially disrupted the educational community. That's number one. Number two, I feel like free speech is in the eye of the beholder. And at times politics is involved, right? And then I'll just wrap up. So I have a few minutes left. I'll just wrap up by telling you, student one is a student at a public university. They used a racial slur on their social media, and the racial slur did not cause a substantial disruption to the school community. So they faced no discipline from their university, but they were dismissed from their sorority or fraternity because the sorority / fraternity is not a public entity. It's a private entity, and it is legally permitted to have its own code of conduct, and it can regulate the speech of its members. So that person lost their case and they were dismissed. And the student number two made a pro-Hamas post on social media. This student is a student at a private university. However, let me just say that they are facing discipline within their private university for code of conduct violation. And that case is still pending. And we are strenuously defending that the speech is protected under the First Amendment. It is not substantially disruptive to the educational community, and we'll see how that plays out. The thing to keep in mind, and I'll close with this thought, is that you have the right to free speech, but it's not absolute. And the things that you put on the internet, when we say you have a right to free speech, that means the government is not going to punish you for making the speech. It does not mean that you will not have consequences. You may lose friendships, family members, your job, your livelihood, your reputation. And those things, folks, are not protected by the First Amendment. So keep that in mind. And that's something we need to teach our students who are growing up in this age of social media, that what they say can hurt them. It can impact their lives. And this right to free speech is not a get out of jail free card to say anything you want. There are consequences. Okay? Any other questions?
I was gonna say that I believe is it for questions because you did answer some as we were going along. So thank you for that, Kathy. And thank you so much for your presentation. I really appreciate it, and I know everybody else does. If anyone has any questions that they think of later, we do have our Q&A panel at 4:00 p.m. today. Otherwise, the link for the evaluation should be in the chat. Please fill that out because like I've been saying, we do value your feedback. And then we will be back at 3:00 for our final presentation before the panel, I believe. And when that comes through, be sure to answer the poll when that comes up. And otherwise, we will see you at 3:00.
Thank you, Renee, and thank you, everyone.
Thank you, Kathy. Hey, Renee.
Yep.
That would be a nice break, but I
Oh,
think I'm coming
sorry.
back in at 3.
Sorry. Yep, that's my bad. Thank you.
Sure thing.
Okay, sorry about that, everyone. We will be back at 3.